The
President, please be seated. The court is now back in session. This morning we already had a hearing concerning pardon and amnesty, and the chamber has also noted the observations by the co-prosecutors. Next, we proceed to the lead co-lawyers for the civil parties to make their own oral submission in response to the observations made by Ieng Sari's defense team. The President, Counsel Ang Odom, you may proceed. Counsel Ang Odom. Mr. President, as you indicated this morning, the defense counsel for Ieng Sari would request that Mr. Ieng Sari is excused and observe the proceeding from the holding cell because he cannot remain seated more than 20 minutes. The President, Mr. Ieng Sari is now permitted to be excused from this courtroom, and that he will observe the proceedings from the holding cell through the AV installed equipment downstairs. The security personnel are now instructed to bring the accused to the holding cell.
The
President continues. The AV section is now instructed to make sure that the AV system is installed so that Mr. Ieng Sari can fully observe the proceedings. Mr. Pek Ong, you may now proceed. Counsel Pek Ong, Mr. President, Your Honors, the response by the lead co-lawyers to be made in a moment will be done first by Mr. Olivier Bahugne and then Mr. Hong Kum Suan, followed by finally Ms. Silke Stutzinski. The President, the Chamber will allow the civil party lawyers to proceed with their oral submissions. And you will have 3 minutes for this, rather 30 minutes for the whole oral submission by the 3 people.
Mr. President, honorable judges, good afternoon. I would first of all like to say that we support the arguments of the co-prosecutors in their entirety. However, we would like to complement them with some facts and considerations as follows. As a matter of fact, before analyzing the constitutionality or the scope of the application of the 1996 Royal Pardon and Amnesty, we think it's important for us to analyze the circumstances under which the Royal Pardon and Amnesty were obtained. I say obtained, not granted. Was the Royal Pardon not obtained under the threat of weapons, hostage taking, and the amputation of Cambodian territory, and the suffering endured by the Cambodian people. The socio-economic context of the years prior to the signing of the royal decree have shown that the Khmer Rouge leaders permanently refused to join the peace process. A peace process as part of which they had to assume responsibility for their past actions. In 1990, prior to the meeting of the UN Security Council permanent members, war was raging in provinces in Cambodia, Battambang, Persat, Kampong Chnang, Kampong Thom. The fighting plunged the country in mourning, and 150,000 people were rendered hostages or refugees, and tens of thousands of refugees were caused. Some people compare the fighting to what happened between 1975 and 1979 with the same cohort of horrors. The government in power had to devote 40% of its budget to trying to restore peace. When members of the UN Security Council met on the 26th of November in Paris, the Khmer Rouge pursued their actions, and people who've had to flee the war-torn zones were to the tune of 186,000. All were working to find an agreement for reconciliation and pacification, except for the Khmer Rouge, which was opposed to this and pursued the armed struggle. The UNAMIC, United Nations Advanced Mission, could not do its works. As such, a helicopter of UNAMIC was fired at, and the second in command of the mission was wounded. The Khmer Rouge were viewed by the Cambodian people and the international community as the only obstacle to true peace. At the end of the year, the armies continued fighting, causing thousands of victims and refugees. At the time, it was impossible to create a neutral political environment because of the refusal of Khmer Rouge leaders to join the peace process, because of the threat represented by the continuation of the struggle in zones under Pol Pot, Ieng Sari, and Khieu Samphan, and the extreme political sufferings which took the form of physical elimination and harassment of people. The first authority of the United Nations in Cambodia recognized that there was no neutral political environment that was conducive to free elections, and he said that on the 19th of December 1992 and on 11th of January 1993, declaring less than 5 months before the elections that the indispensable political neutrality was not present. As a matter of fact, the Khmer Rouge leaders called for a boycott of the 1993 elections. At the same time, 372,000 refugees waited in makeshift camps. They were victims of the fighting. On the 1st of August 1993, UN soldiers based in Cambodian territory were attacked by Khmer Rouge troops. UN peacekeeping troops were detained. In late 1993, there were elections held, and 90% of the people participated in the elections. The Khmer Rouge could only kill and cause havoc. On the 1st of August 1994, the war continued, and military activities absorbed at least 28% of the national budget, and this caused a generalized climate of insecurity and armed robbery. The government had to solve the problems of a country that was devastated in its human resources as well as its equipment. the 1993 agreement, which was a testament to the will to pacify the country, was being promoted. But for the Khmer Rouge that sought to propagate violence, and they tried to haggle their pardon using their electoral following and the stranglehold they had over the country, Khieu Samphan refused the demand for a ceasefire as a precondition for negotiations. That's why on the 7th of July 1994, a law was adopted by the 103 members of parliament outlawing the Khmer Rouge group. Against this backdrop, extreme violence was such that Ieng Sary took advantage of the vulnerability of his country and his people and the instability in the country to wrest his pardon. On the 2nd of November 1993 in Phnom Penh, the first Prime Minister Hun Sen took the floor to condemn Ieng Sary and bad politicians who were holding up the integration of troops in the Royal Armed Forces and who were acting as if they wanted to create a tripartite army. Under the threat of amputating territory under their control and pursuing the armed struggle as well as the violence they were perpetrating, the leaders of the Khmer Rouge, particularly Ieng Sary, haggled for pardon. More than 376,000 people were deported, and events were similar to those committed during the Democratic Kampuchea regime. Ieng Sary's pardon decree was obtained. First Prime Minister Hun Sen argued that it was to save the nation that he did this. This declaration is proof of threats and constraints imposed by Ieng Sary. The decree was signed by the king and countersigned by the two prime ministers. Furthermore, the king insisted on ensuring that 2/3 of the National Assembly signed the decree before it was published. No vote or debate took place in National Assembly. On the contrary, members of the Assembly were consulted in a private capacity. They were asked to sign it to show their agreement. As such, the National Assembly did not sit. It is obvious that had there been serenity, the absence of threats, the absence of hostage taking, this pardon would never have been granted. The chamber will therefore apprise itself of this fact, which should be taken into consideration, and they should consider this pardon null and void. If they reach a contrary finding, it would be proof that terrorists can use violence and sequestration to obtain to be acquitted of their crimes. I thank you.
Council Hong Kum Suan. Mr. President and Your Honors, I am Hong Kum Suan. My international colleague, Mr. Sinsky, and I will respond to the observation or the objection of Ieng Sary defense with regard to the royal pardon and amnesty. We will focus our response on the impact that a pardon and amnesty have on victims of mass crimes and examine whether these are violations of the international obligations of the royal government of Cambodia towards victims. We submit that if the pardon and amnesty are held as valid, these conflict with the internationally recognized rights of victims of serious international crimes. Consequently, we submit that the royal pardon and amnesty must be held to be invalid before the ECCC. If Mr. Ieng Sary escapes from being held accountable for this alleged commission of international serious crimes, this would hinder the general rights of victims. In that, impunity would continue to reign. Impunity is the enemy of reconciliation and justice. International standards regarding victims and in particular victims of mass crimes. Since after World War II, the right of victims to an effective remedy has been enshrined in all major international and regional human rights instruments. The idea of a remedy has developed and extended to encompass specific duties to carry out a full and effective investigation and uncover the truth of past events. International human rights law has dovetailed with international criminal law proceedings and have become an inherent and integral part of international criminal justice mechanisms. Human rights in themselves are largely declaratory and ineffective without a corresponding enforcement mechanism, such as criminal proceedings to deal with historic mass crimes. Remedies are the means by which a right is enforced, or the violation of a right is prevented, redressed, or compensated. The term remedy entails two components. One, the procedural component relating to the process in which claims of human rights violations are heard and decided. Two, the substantive component comprising the outcome and relief afforded. In the context of the royal pardon and amnesty, we focus on the first part of the meaning of remedies. It is clear that a right to an effective remedy for victims is a well-established principle under international human rights law. The UN Declaration on Human Rights, 1948, guarantees in Article 8 the right to an effective remedy by the competent national tribunals for acts violating the fundamental rights granted to him by the Constitution or by law. The International Covenant on Political and Civil Rights contains a similar provision that each state party ensure an effective remedy to any person whose rights and freedoms are recognized in the covenant are violated. It details that this remedy is to be determined by a competent judicial, administrative, or legislative authority. The Convention Against Torture adds the right to complain and to have his case promptly and impartially examined, and the right to compensation and rehabilitation as a form of reparation as one important component of an effective remedy. The general right to the effective remedy is also addressed in the International Convention on the Rights of the Child, the International Convention on the Elimination of All Forms of Racial Discrimination, the Hague Convention respecting the laws and customs of war on land, the additional protocols to the Geneva Conventions, and the Rome Statute of the International Criminal Court. The equivalent provision under the African Charter on Human Rights provides the right to have his cause heard. This has been interpreted in case law that the state must provide effective remedies to its citizens. Recognition of the right to effective remedy has also been included in decisions of regional bodies such as the European Convention and the Inter-American Convention. Guidance about what constitutes an effective remedy can be obtained from the Human Rights Committee, which underlined three important components: the duty to investigate, the duty to prosecute and punish, and the incompatibility between amnesty laws and the rights to the remedy. The interconnectivity between human rights law and international criminal law is lucid when such a human rights body explicitly links state obligations such as criminal proceedings as an effective remedy and responses to serious human rights violations. In addition, case law of regional human rights courts has strengthened this approach. In Rodriguez against Uruguay, the committee urged the state party to take effective measures to carry out an official investigation in the plaintiff's allegations in order to identify the responsible persons and to enable the victim to seek civil redress. The Human Rights Committee stated in Bautista against Colombia, with regard to an effective remedy, the state party is under a duty to investigate and to prosecute criminally, try and punish those held responsible for violations of human rights such as abduction, disappearance, torture, and death. Furthermore, the Human Rights Committee clearly states in its comment number 20, amnesties are generally incompatible with the duty of states to investigate such acts, to guarantee freedom from such acts within their jurisdiction, and to ensure that they do not occur in the future. To conclude and summarize, the right to an effective remedy encompasses the duty of the state to properly investigate, prosecute, and punish for the violation of rights that are guaranteed in human rights instruments, and amnesty laws are incompatible with these rights. The fundamental right to an effective remedy was crystallized in the United Nations Declaration on the Basic Principles of Justice for Victims of Crime and Abuse of Power, 1985. The UN Declaration articulates the scope of an effective remedy. It gains victim access to justice, information, and a voice in judicial proceedings. Similarly, Principle 19 of the UN Updated Principles of Combating Impunity 2005 indicates that states shall undertake prompt, thorough, independent, and impartial investigations of violations of human rights and international humanitarian law and take appropriate measures in respect of the perpetrators, particularly in the areas of criminal justice, by ensuring that those responsible for serious crimes under international law are prosecuted, tried, and duly punished. In 2005, the UN Basic Principles on Victims were adopted by the UN General Assembly and extended and detailed in 1985 Declaration, focusing specifically on victims of gross violations of international human rights law and serious violations of international humanitarian law. Although these principles do not have a legally binding character of ratified international treaties, many have equated the level of customary international law. I would like now to proceed to my colleague Silke Stutzinski to continue.
Good afternoon, Mr. President, Your Honors, dear colleagues. I will continue with our submission. The remedies for victims under the UN Basic Principles can be grouped into four main categories. First, access to justice. States have to provide for victims of gross violations fair, effective, and prompt access to justice, with reference to general access to judicial bodies to achieve appropriate remedies. This does not necessarily mean at the outset a criminal proceeding. However, since the identification and liability of the perpetrators is required as a condition to reparations as a remedy, the right of access to justice indirectly includes criminal investigation of the violations that constitute international crimes as a prerequisite to holding the persons liable and to enable a reparation claim to be made against the responsibles. Since the state's obligation with regard to reparation is subordinated to the individual obligation to provide reparation, this aim can only be achieved if the individual perpetrator is identified and brought to trial. Importantly, access to justice must be fair, prompt, and effective, which obliges states to react immediately after a gross violation occurs. To be effective, substantial remedies must be seen and received. Second, investigation, prosecution, and punishment. Investigate violations effectively, promptly, thoroughly, and impartially, and, where appropriate, take action against those allegedly responsible in accordance with domestic and international law, can be found in Article 2(3)(b). In cases of serious violations, states have a duty to investigate and, if there is sufficient evidence, the duty to submit to prosecution the person allegedly responsible for the violations and, if found guilty, the duty to punish her or him. The mechanisms of the Human Rights Committee demonstrate that the criminal component, including state obligations relating to this, is an essential part of the remedies for victims. This obligation cannot be barred by a statute of limitation. The provision in Article 4(6) stipulates that a statute of limitation does not apply to gross violations of international human rights law and serious violations of international humanitarian law, which constitute crimes under international law. This is a strong basis for our submission that criminal prosecution is an important component of state obligations with regard to victims' rights. Third, access to information on the causes and access to truth. Access to relevant information concerning the violations and reparation mechanisms, including the causes leading to their victimization, is a fundamental right for victims. Moreover, being informed about the causes and conditions pertaining to the gross violations and to learn the truth in regard to these violations is recognized as part of the right to an effective remedy. Access to the truth means access for specific individual victims, their families, and their communities, including understanding the causes and obtaining adequate answers to the important question why crimes happened and why they happened to them and their families. Proper investigations by a state in criminal proceedings are likely to discover what has happened and satisfy the information needs of individual victims and communities. The effect of validating any amnesty given to defendants of mass crimes constitutes an obstacle to the ability to access information about facts and circumstances surrounding an international crime and consequently negates the guarantee of victims' right to an effective remedy. Number 4, access to reparation. All major human rights instruments, including the UN Basic Principles, set up the right to reparation to be made against the person or persons who are held liable for the crimes. Following that, if the responsible are unable to satisfy the reparation requests, the responsibility falls on the state. We will highlight how both the pardon and amnesty conflict with victims' and civil parties' rights to be compensated for loss, damages, and personal and direct harm. To conclude, international standards for victims of gross violations that constitute international crimes and their right to effective remedies include state obligations to investigate, prosecute, and try those responsible, as well as providing the means to access to justice, information, and reparation. We will now examine the royal pardon and the amnesty and their validity in the light of aforementioned state obligations towards victims at the international level. The pardon that Mr. Ieng Sary was granted for the 1979 conviction and the amnesty for prosecution of crimes under the outlawing law, if held valid, would lead to full impunity of one surviving senior leader of democratic Kampuchea. According to the set of principles for the protection and promotion of human rights through action to combat impunity, impunity is defined as, I quote, the impossibility de jure or de facto, legal or factual, of bringing the perpetrators of violations to account, whether in criminal, civil, administrative, or disciplinary proceedings, since they are not subject to any inquiry that might lead to their being accused, arrested, tried, and, if found guilty, sentenced to appropriate penalties and to making reparation to their victims." Unquote. If the pardon and amnesty were held to be valid, there would be no other national or international mechanism to hold Mr. Ieng Sary accountable, or any legal remedy for the victims. Such impunity would conflict with the rights of victims in international human rights law and falls way short of meet the requirements of international standards in this area. Moreover, that would be in violation of state obligations with regard to victims as stipulated in international instruments and case law. The royal government of Cambodia has ratified all relevant international conventions and adopted the UN Basic Principles and has the obligation to comply with them as stated in Article 31 of the Cambodian Constitution. Consequently, the same applies to the ECCC, as it is a court within the national judicial system. A total impunity granted to one of the senior leaders, Mr. Ieng Sary, would amount to a serious violation of state obligations by the royal government of Cambodia towards victims of mass crimes. For victims and civil parties, validating the pardon and amnesty would mean an effective exclusion of their right to access justice, information and truth, and the right to have crimes properly investigated, prosecuted, and tried with regard to the case against Mr. Ieng Sary. Such a state of impunity would violate the international obligations of the royal government of Cambodia and thus the obligations of the ECCC. Mr. Ieng Sary has submitted that victims are not precluded from an effective remedy because the pardon and amnesty protects only him and not the other accused. Contrary to this, internationally recognized victims' rights cannot be said to be remedied merely because other senior leaders are prosecuted. In the absence of a Truth and Reconciliation Commission or other mechanisms discontinuing the criminal proceedings against Mr. Ieng Sary would exclude significant portions of the history relating to his personal responsibility as a member of the Standing and Central Committee of the regime, effectively denying victims the right of access to information and the full truth. Since it is alleged that the senior leaders planned and performed various crimes pursuant to a joint criminal enterprise, the alleged criminal contribution of Mr. Ieng Sary to the overall enterprise is a crucial and significant piece of the parcel which cannot be removed from the case on the basis of the pardon and amnesty. If the case of Mr. Ieng Sary is dismissed, the victims who suffered direct and personal harm as a result of his alleged actions would be deprived of having their harm properly and fully addressed. Finally, any reparation to be borne by the accused would simply fail if Mr. Ieng Sary escapes accountability, as victims and civil parties would have only 3 accused against whom they could direct their reparation claims if convicted. Since Mr. Ieng Sary is considered to be the wealthiest amongst all accused persons who possess assets in Cambodia and abroad, dismissing his case would significantly reduce the enforceability of any reparation awards. To conclude, holding the royal pardon and amnesty valid would, in addition to all the other arguments made in this submission, not only violate the court's international obligations towards victims and in particular civil parties, It would also be an affront to the pain, suffering, and damages done to these individuals, their families, and their entire communities, given that Mr. Ieng Sary allegedly partook in destroying the very fabric of Cambodian society. Therefore, civil party lawyers respectfully request that the defense objections concerning the royal pardon and amnesty be dismissed, and that the Chamber declares that the royal pardon and amnesty is not valid before the ECCC. Thank you for your attention.
The President, thank you, civil party lawyers. To continue, the Chamber give the floor to the defense lawyers to reply to the response if they wish to do so.
Good afternoon, Mr. President. Good afternoon, Your Honors, and good afternoon to everyone in and around the courtroom. I will briefly respond. I'll just hit the highlights, if you will. I'll start off with the National Co-Prosecutor's remarks. In particular, he began by, as I recall, indicating that there was no need to call witnesses, and the International Co-Prosecutor also made the same remark. And of course, they were relying on the pretrial chamber's interpretation of what, of course, were the intentions of the king and, of course, the prime ministers and everyone else who might have been involved in the negotiations. With all due respect to the pretrial chamber, they were not a party to the negotiations, and what they made divine to have been the attention of the king is not sufficient in our respectful submission, because the best witnesses that are capable of explaining what the intention was are the parties who engaged in that negotiating process. We especially think now that it is necessary to have testimony on not only the language but the intent behind the amnesty, because again we have the prosecution now informing us or declaring what it was that the Prime Minister had indicated in his political statements as to what he intended the amnesty to entail. And then, of course, we hear more hearsay as to what the Prime Minister may have told somebody else who has a UN title, and therefore there's no need. So for all those reasons, Your Honors, we believe that our submission is the correct one and that it should be granted, because there is ambiguity not only as to the text but also as to the intent behind it, and that seems to be one of the fundamental arguments in this case. Next, let me address briefly how the 1994 law has been interpreted by the prosecution, and how, in our respectful submission, at least there seems to be their interpretation would lead to an absurd result. And I don't mean this in a pejorative sense. It's not an attack on the prosecution, but merely that what they're claiming seems to be an absurdity. And that is that the amnesty that Mr. Ieng Sary received, based on their interpretation, would kick in after Mr. Ieng Sary went through a trial. In other words, Mr. Ieng Sary in 1996 agreed to be retried again, and if found guilty, he would then benefit of a pardon. That is an absurdity. Or, to even make it more absurd, that after this particular trial, irrespective of what you may find with respect to our jurisdictional issues, that if in the event Mr. Ieng Sary is convicted, he can still benefit from the amnesty itself. That's what I took away from that argument. Clearly, Mr. Ieng Sary intended to be amnestied and not to be prosecuted for any crimes that he may have been involved in or associated with during the relevant periods. Full stop. Not that he had negotiated that he could be retried. And if that were the case, why did not the Cambodian government prosecute him in 96 when he came over, or 97, or 98? Where was the UN to say arrest him and prosecute him? Nowhere. So that's why that interpretation fails. As far as what the 1994 law covers, what it's supposed to cover, I urge the trial chamber to first read the law in its entirety, starting with the preamble. But also, speaking of public remarks, Mr. Sam Rainsy, who had been finance minister in 1994 and had participated in the National Assembly at the time, in fact, I believe he was with Funcinpec when he was the finance minister, he made it very clear as to what the intention was behind the passage of the 1994 amnesty law. And he was quite clear that it specifically covered crimes that had taken place during the period of the Khmer Rouge rule from 1975 to 1979. Now, we've cited this material, Your Honor, so I don't want to belabor the point. It's in our submissions. But clearly that was the whole purpose of that amnesty law. And I've already explained how we believe that law should be interpreted in conjunction with the amnesty. So I won't go over that again. I don't think repetition is persuasive, especially since I believe I was rather clear this morning as to how we feel and stand on that particular issue. Now, the international co-prosecutor was rather frank this morning, and we wish to thank him for saying what the quid pro quo. What Mr. Ieng Sary got was life. He got to keep his life, in other words. That he was not going to be executed or put in prison for the rest of his life. And of course, that's the argument that we were making yesterday and today, which is why that trial, for all its faults, produced a legitimate verdict, one that would have been acted upon, and one that required a pardon from the king. So that's why these two arguments, the nebis in idem and the RPA, are effectively, they go hand in glove. They're tied together. But it validates the point that we have been trying to make. As far as what is or is not customary international law and what is applicable, and I understand Your Honors have taken an oath to exercise your discretion. And we appreciate that. And of course, I don't think that there's a single person here in courtroom that would say otherwise. We do think, and we do submit, that the law is not quite as crystal clear as the prosecution would have you believe, albeit they use this term crystallization. It has crystallized. And how do they do so? They do so by pointing out to one or two cases. One or two cases do not crystallize into a customary international law. You need state practice and opinio juris. We've discussed this extensively in our brief, so I won't belabor the point. But suffice it to say, simply because you have a judgment or a decision from one particular court, that in and of itself, while it may be instructive, it certainly is not enough to constitute customary international law, or at least the principles for which it is being argued. The same thing goes with remarks made by the UN Secretary General. Yes, he is entitled to make remarks which what he believes may be indicative, opiniones, and we support the fact that as the law is progressing, the law is becoming clearer, and of course international criminal law is evolving. But we have to keep in mind a couple of things. Throughout these proceedings, where we're dealing with these legal issues, but also throughout the trial. First and foremost, Ms. Ieng Sary, as well as the others, are being tried under the criminal codes that would have existed at the time. What was the customary international law at the time? What was the law applicable in Cambodia at the time? And so when you look at the amnesty that was provided in 1996, what was the law at that time? Not what is the law today or thereafter. What was it at that time? And again, by way of example, if indeed the law was as settled as the prosecution would have you believe, then why on earth would the UN participate in the negotiations at Abidjan with Sierra Leone in order to bring the fighting to an end? And what they signed off and what they remarked was postscript. It was after the signing that they entered. Oh, and by the way, not before, not during, at no time did the United Nations, prior to the signing, indicate that this is impermissible. And we stand by what we've indicated earlier. Yes, states should not be engaged in violating any of these norms. And yes, they do have an obligation to prosecute. But there is also that discretionary power still left to states to grant amnesties. And the granting of the amnesty, now directing my remarks to one of the civil parties, we began hearing sort of the historical background as to how the amnesty was given, and in a sense, what I took away was Mr. Ieng Sary blackmailed the Cambodian government into offering him an amnesty. Well, I have news for the gentleman, and that is, that's the whole purpose of an amnesty, to stop a situation that's ongoing. It's regrettable. In granting the amnesty, one authority has the power to grant it. It doesn't necessarily mean that one of the authority granting it is in the right. What it means is it has the power to grant it. And in this instance, as I said yesterday, the proof is in the pudding and in the tasting, in that by granting the amnesty, the purpose of it was to stop the bloodshed, stop the conflict, and it did stop. And today, if there is peace in Cambodia, if there is a unified political system in a sense that people go and vote their choice and there's no armed conflict, is because Mr. Ieng Sary began that process in 1996. Now, we heard that, but wait a minute, if you give him this amnesty, and if you find that this amnesty applies, effectively what you will be doing is promoting impunity. And here's what I have to say to that. In principle, I agree that everyone deserves justice. No doubt about it. But I also am a fundamental believer in the power of the law. And the law has to be applied whether we like it or not. It is not a technicality. It is not something that we can just ignore when it's inconvenient or when difficult decisions need to be made. Granting an amnesty for the government and for the king to have signed it was a difficult and perhaps even painful decision, but nonetheless it was one that was necessary and one that the powers that be, who had the authority to do so, recognized was important at the time. All we are asking you, Your Honors, is to look at the law carefully. Look at the amnesty. Since there is ambiguity, let's clarify that ambiguity. But at the end, your decision should not be based on whether one party is not going to receive their day in court. It's going to be on whether the law is applied, and we have to apply it consistently throughout these proceedings and in every court, no matter where we are. And I know, Your Honors, that you will do your level best in exercising your wise discretion on this matter, and at the end, we will abide by the decision and go forward no matter what the situation is. Thank you very much.
The President. Thank you, Council. It is now time for us to take a short recess. We'll take a 20-minute recess, and we will come back at 2:50. All rise.